Hi guys, and welcome to Attorney Job Vlogger, Law for the Everyday Layman. Today we have part 3 on the law on contracts, and specifically we will talk about the form and interpretation of contracts as well as the remedy of reformation. Okay? So if you like my videos and you want to see more, please hit the subscribe button. And please remember that this is only for educational and informative purposes and is not a substitute for proper legal advice or for studying and understanding the law. Shout out to everyone who passed the 2019 bar exams, okay? I hope you make the most out of your careers and become great lawyers, okay? Now let's begin with the form of contracts. Okay, when we talk about form of contracts, this is simply the manner by which a contract is executed or manifested. Okay? It is simply the physical instrument in case of a written contract or the oral manifestation of the agreement or meeting of the minds between the two parties. That said, a contract may be in several forms, no? It may be oral, it may be written, it may be partly oral and partly written. A contract may be express, or a contract may be implied. A contract may likewise be informal or simple, or formal or solemn. Okay? When a contract is informal or simple, the law does not require a certain form for it to be valid. But when the contract is a formal contract, the law requires a certain form either for validity, enforceability, or public convenience. Okay? Now, let's talk about the general rule. Contracts are obligatory, okay? Contracts are obligatory in whatever form they may be entered into, provided all the essential elements for its validity are present. And what are those essential elements? COC, no? Cause, object, consent. Consent, object, and cause must be present. If they're all present, and the law does not require a certain form, then the contract is valid. Okay? And when the law requires a certain form, that will either be only for validity, for enforceability, or for greater convenience. Okay, let's talk about validity first. When the law requires a certain form for a contract to be valid, that requirement is absolute. Meaning the parties must observe the form required by law. If the law says it must be in writing, that must be followed. If the law says the contract must be in a public document, that must be followed. When we say public document, by the way, that is a document which has been notarized. If there is no notarization, it's only a private document. Notarization converts a document from a private character to a public document. Okay? So now what contracts must be in writing, in order to be valid? First, we have donations of personal or movable properties, no? Which exceed 5,000 pesos. The donation and the acceptance must be in writing. Next, in case of a sale of a piece of land through an agent, what must be in writing is the authority of the agent. Not the sale of the land. Of course, it's better if the deed of sale is in writing, no? That will always be better. But what the law requires to be in writing absolutely is that the authority or the SPA of the agent must be in writing. Otherwise, if the authority of the agent is not in writing, then the sale of the land will be void. Okay? I have another video on SPA, no, and agency. Just check it out, okay? But please remember, it's the authority or the SPA of the agent that must be in writing. And if it is not, the contract of sale of the piece of land will be void. Another contract that must be in writing is anti-crisis. No, I also have another video on that. Please just refer to that. But the law requires that the principal and the interest must be in writing in order for the anti-crisis to be valid. Now, what are some documents that must be a public document in order to be valid, no? In case of donations of an immovable, the donation must be in a public document. As for the acceptance, it may be in the same document or it may be in a separate document, okay? Another one is in case of partnerships where there has been immovable property or real rights to immovable property which have been contributed to the common fund. Okay, that must appear in a public document as well. Okay, and as for registration, we have a chattel mortgage and sale of large cattle. Those contracts must be registered with the respective registry of deeds. Okay. Now, when we talk about the requirement of enforceability, this will be discussed more in depth when I release my video on unenforceable contracts. Okay? Because the law requires some contracts to be in writing in order for them to be enforceable. When we say enforceable, what does this mean? Capable of being proved. Proved where? In court. Okay? And the contracts which must be in writing in order to be enforced or provable are contained in the Statute of Frauds or Paragraph 2 of Article 1403 of the Civil Code of the Philippines. Okay? Now, that is not to say those contracts are not valid. Those contracts exist. But the problem is that they may not be enforced, no? Because how will you prove that they actually exist? Which is why the statute of frauds is actually a rule on evidence. And if there has been partial performance, then the problem of unenforceability is no longer that material. Why? Because you already have partial performance to use as proof that said contract exists. Okay? So, without such partial performance, the law requires some contracts to be in a certain form in order to be enforceable or to be capable of proof before the court. Okay? And finally, we have the requirement of greater convenience or efficacy, no? Now, again, you remember my statement earlier that I said if a contract is executed between the parties only and has not been notarized, it is merely a private document. In that case, that private document is still valid, it's still binding, no? But it is only binding between the parties to the contract. Okay? Now, if you want to bind third parties or the whole world, or in other words, you want to create a real right, no? You need to notarize that document. Not you go to a notary, no? You have the document notarized by a notary public. Okay? Because the effect again of notarization is to turn that private document into a public document which is now capable of being enforced against the entire world or even against third parties. Okay, and that is what it means by greater convenience or greater efficacy. Okay, now you will see Article 1358 in the Civil Code, no? It gives us a list of certain contracts or acts which must be contained in a public document. Now, you may think that that requirement to be placed in a public document is for validity. No, it's not. The requirement that the contracts in 1358 appear in a public document is only for greater convenience, to bind third parties. It's not for validity. And what are these that 1358 lists? First, we have any act which creates, transmits, modifies, or extinguishes real rights over immovables. Second, we have the cessation, repudiation, or renunciation of hereditary rights or the conjugal partnership of gains. Third, any power to administer property or any act prejudicial to third persons. And fourth, the cession of acts or rights from an act which is contained in a public document. Those that I mentioned, those four, must appear in a public document to bind third persons, not for validity. Okay? So, that's it in general, no, for the form. And now we can move on to the remedy of reformation. So what is reformation? Reformation is a remedy allowed by law for to cure or amend or correct, okay, a written instrument which fails to reflect the real agreement or intention of the parties. Why? Because that written instrument fails to express the real agreement or intention of the parties because of mistake, fraud, inequitable conduct, or accident. Okay? So, in these cases, the law allows the party who is injured to ask for the remedy of reformation from the court. Okay? So, this remedy of reformation will only be allowed if there is a written document. Okay? In other words, there will be no reformation if there is no document. Okay? Because if there is no contract, no document, no written evidence, then there is nothing to be reformed. Okay? So that's how simple it is, no? There is a meeting of the minds, no? The meeting of the minds on the agreement by the parties upon the essential requisites, no? There is consent in the meeting of the minds upon the object and the cause of the contract. If all those exist, then there is a valid contract. And then there is a problem in the document, no? The physical manifestation of the thing. And that is what is going to be corrected, not the original agreement in the minds or the intention of the parties. Okay? So, this remedy of reformation is really a remedy in equity. And the courts, in granting this remedy of reformation, they are not making a contract for the parties and they are not making a new contract for the parties. Okay? They will only be enforcing what the parties originally intended. And if there was no meeting of the minds at all, then there is no contract. Okay? It's void. Okay? Now, let's go to the requisites of a reformation, no? First, of course, there must be a meeting of the minds. Consent must have been given. Second, the instrument, the written instrument, does not express the true agreement or the intentions of the parties. And third, the failure of the instrument to express the true intention of the parties is due to mistake, fraud, inequitable conduct, or accident. Okay, those four grounds. And finally, no, the facts concerning the circumstances must be put in issue in the pleadings, and the grounds must be clearly and convincingly proven. Okay? Okay. Now, there are certain instruments which the law says are capable of being reformed or being the subject of reformation. Okay? First, we have a document where there has been a meeting of minds, you remember, no? But the document has been made and both parties are guilty of a mistake. Okay? In other words, there has been mutual mistake. And what is the nature of this mistake? It must be a mistake of fact. Okay? I'll be discussing more on the concept of mistake when I talk about voidable contracts, which is coming very soon. Okay? But for now, just remember that there is mutual mistake. And in this case, who between the parties is entitled to ask for reformation before the court? Either party, because the mistake is mutual. Okay? Neither party is guilty of fraud, bad faith, or whatever. Okay? So in this case, either party may bring an action for reformation. Okay? Second, we have the case where one party is guilty of a mistake, no? He is mistaken in the drafting of the contract or in understanding the contract, no? So it does not reflect his true intention, but the other party is guilty of either fraud or inequitable conduct. Okay? And in that case, the only party who can bring the action for reformation is the party who is guilty of mistake, because he is not in bad faith, no? He simply committed a mistake. But the party who will suffer, no, the strict interpretation or will suffer from the reformation of the contract is the party guilty of fraud or inequitable conduct. Third document which can be subject of reformation. A document where, again, one party has committed a mistake, but the other party knows of that mistake or believes that there is a stipulation that it should be reformed and conceals that fact. No, he hides it from the other party. Probably thinking, makakaisa ako, or thinking na I'll put one over you, no? I will have the undue advantage, no? So in that case, same as with the case earlier, it is only the party guilty of mistake, no? Or who has committed the mistake that can bring the action for reformation. Next, we have a document which is drafted, but due to the ignorance, the lack of skill, the negligence, or the bad faith of the person who was drafting the contract, maybe it's a secretary or whoever, no? The contract does not express the real agreement or the true intention of the parties, no? And in that case, reformation may likewise be prayed for. Okay? Finally, we have a case where the real agreement is a mortgage, sorry. The real agreement is a mortgage of real property or pledge of personal property. But the document says it is a contract of sale. Okay? Remember the rule, no? Now we determine what a contract is by its terms and stipulations and not by the title. Okay? If the terms say it's a mortgage but the title says it's a sale, we determine it by the stipulations and not the title. Okay? So in this case, where the parties had intended a mortgage, okay, and but what is stated is it's a contract of sale, whether it's an absolute sale or a sale with right to repurchase, such as a pacto de retro sale or in conventional redemption, then the reformation of the contract is likewise proper. However, there are some documents that the law says reformation cannot be had. Okay? What are these? Let's say first example, no, is a simple donation inter vivos, meaning during the lifetime of the donor. Okay? Which has no condition attached. In this case, the donee cannot ask for reformation. Why? Because a donation is an act of pure beneficence or liberality. So the donee should not be able to ask for reformation. If anything, it is the donor who can ask for reformation or even revoke the donation, subject of course to the rules on donation in the Civil Code, no? So no reformation in a simple donation with no condition attached, okay? Inter vivos, during the lifetime. Second, wills, okay? I have a video on wills in succession, no? So just check that out. But wills are not subject of reformation and may even be revoked by the testator or the person who made the will during his lifetime. Of course, he can't revoke it after he's dead, no? Okay, and last case which cannot be subject of reformation is where the real agreement is void. Okay? Of course, since the real agreement is void, there is nothing to be subject of reformation. Okay? So, last point when it comes to reformation. If a party asks for enforcement of the contract, okay, he's asking for specific performance or that a certain stipulation in the contract be enforced, he cannot subsequently ask for reformation. Why? Remember, reformation is asking the court to make the contract reflect the true agreement of the parties. If the party had actually asked for enforcement of the contract, he cannot ask for reformation because by asking for enforcement or specific performance, he is already stopped or he has even ratified the contract by admitting its validity. Okay? And he cannot thereafter ask for reformation. Okay? So with that, we're done with reformation. Let's go now to interpretation of contracts. Okay? Here, in interpretation of contracts, there may be different meanings on terms or clauses, but the general rule is, if the words are clear, no, and there is no doubt, then the literal interpretation of the contract will apply. Okay, why? Because the law is the contract between the parties. And it is presumed that when they gave their consent, that it was voluntarily given, no? That they knowingly and with full awareness entered into the contract. So, the literal meanings of the stipulation will govern, especially when the words are clear. Okay? So when the words are clear and can be easily understood, there is no room for construction or interpretation of the contract. Okay? There is no need to interpret if the words are clear. Okay? Now, the contract itself contains terms and stipulations. That in itself is already the best evidence of the intention of the parties. They had all the time, let's assume they had all the time in the world to prepare that, no? So they could have just used proper words and terms to reflect their intention. However, there are cases where either by their fault, negligence, or whatever other reason, no? There are doubtful words or ambiguities in the contract. So the law gives us certain rules, no? So, the general rule again is the words will determine, no? The effect of the contract, okay? But in case the words are doubtful, then the evident intent, okay, of the parties will govern. And how do we determine what the evident intent of the parties are? The law says we will examine their contemporaneous, yung sabay, or subsequent acts, okay? What they have done while executing the contract and acts subsequent to the contract. Okay? Now, in case there are general provisions and special provisions, of course, a special provision will prevail over a general provision. When we say general, it covers a huge subject matter. And then, of course, we can have special ones, no? Like, in case of this event, this will happen. Okay? That's just one example, no? So, in that case, the mere fact that the parties stipulated for special provisions means that they intended the special provision to apply in that case. Okay? And it will prevail over the general condition. Okay? And when it comes to general provisions, no? General provisions are only understood to relate to the subject matter which it talks about, no? In other words, if my subject matter is this bottle of water, of course, I'm not talking about a piece of land or a cell phone. Okay? All my terms and stipulations about a bottle of water must necessarily relate to a bottle of water. Okay? So that's how simple it is. Okay? Now, in case there are several stipulations now, no? The rule is that all the stipulations in the contract must be taken together. Okay? You understand them together to give the whole contract, to aid in the interpretation of the whole contract, no? All stipulations should be interpreted together to give meaning also to those stipulations which are doubtful. Okay? In when you may have probably learned this in grade school, no? Context clues. You derive the meaning of a thing from its context, okay? And that is a mode of interpreting contracts as well. Okay, now let's go to the next rule. What if there is only one stipulation in the contract and it is susceptible of several meanings? Okay, then the rule is we use that interpretation which will make that stipulation effectual. Okay, so like if the stipulation says I will sell to you, let's make it X. X will sell to Y his piece of land, and X has two pieces of land, one of which he is the absolute owner, and the other where he is a co-owner with, let's say, A. Then, of course, that stipulation, to be effectual, will apply to the land of which X is absolute owner, because X cannot dispose of the land which he co-owns with A without A's consent. So in order to render the stipulation valid, we apply it to the one where he is the absolute owner. Okay? So that is for stipulations which are capable of several interpretations. What if it's only a word? Okay? Or words that are capable or susceptible of different meanings, no? So in this case, the rule is we use that interpretation which is most in keeping with the nature or object of the contract. Okay? Because the rule, if you remember earlier, is that the intention of the parties should prevail. No? So like let's say, X offers to sell all his furniture to Y. That does not contemplate the cell phone because cell phone is not a piece of furniture. Okay? So, in that case, we use the interpretation which is in keeping with the nature or the object of the contract. Okay? Now, what if earlier that was words capable of several meanings, no? But what if the words are obscure or they are uncertain, no? Okay, in this case, we cannot be sure, no, of what the actual meaning is, no? So these words will now be interpreted against the party who introduced them, no? In other words, you're using highly technical words or a very ambiguous word rather, no? So that will not be used to favor the person who put them in the contract, okay? Because for more likely than not, the party who introduced them was seeking an undue advantage over the other party, and that is not allowed under the law, okay? So in case there is a controversy and it will seem that the party who introduced the obscure word might win, the interpretation of the statement will favor the other party more because it was the party who introduced them that was at fault. He could have used easier to understand words. Okay? Okay, like now let's go to a more applicable principle. We have what is known as the contracts of adhesion. Okay? When we say contracts of adhesion, I'm sure some, if not all of you, have encountered these, no? These are pro forma contracts that are already printed out, no? And all you have to do is affix your signature. Okay, you cannot negotiate on the terms, you cannot negotiate on the conditions, nothing, you just sign. That is a contract of adhesion. Why? Because it is an agreement where the terms are already set by the other party and the other party only has to affix his signature as a symbol of his adhesion to the contract. Okay? Are these contracts void? No. Okay? The Supreme Court has already said that they are valid. Okay? Why? Because the court will not step in to relieve just anybody from an onerous contract, no? Because parties, again, are presumed to enter into a contract voluntarily and knowingly, no? And with full awareness of all the terms and conditions, no? And the mere fact that it is a contract of adhesion and that the burdens therein are heavy, no, is not a justifiable reason to relieve the party from his obligations. There must be other factors which will justify the court to relieve a party from his obligation. Okay? So the general rule is a contract of adhesion is valid and the other party who is to sign is free to accept it in its entirety or to reject it. Okay? So, what is your remedy if you're the one signing, no? The only thing you have in your favor is that contracts of adhesion will be interpreted strictly against the party who drafted them. Okay? So, let's say there is a loophole in the agreement, okay, that may be interpreted more favorably on your part because in case of ambiguity, in case there's something malabo, no? Then that will be taken against the party who drafted the contract simply because he was the one who drafted it and all you could do was sign. Okay? So that's the rule in contracts of adhesion. They are valid, but they will be strictly interpreted against the party that drafted them. Okay? So, let's go to the... well, earlier we were talking about the specific rules, no? In case of interpretation. And those rules should be the primary rules that will govern, no? However, in the absence of all the foregoing rules, the law also gives us certain, let's say, default rules, no? Like this first one. In case of gratuitous contracts, in case of doubt as to their incidental circumstances, then the ambiguity will be resolved or the interpretation will be in favor of the least transmission of rights. For example, in donation, which is a gratuitous contract because its cause is pure liberality, no? Then the ambiguity will be resolved in favor of the least transmission of rights. Why? Libre na nga, no? It's an act of pure liberality. Do not take away everything from the donor. Okay, so least transmission of rights. Okay, now for onerous contracts, okay, what is the rule? Interpretation will be for the greatest reciprocity of interests. Meaning, something that will work for both parties. So let's say, X and Y enter into a contract of loan where Y can pay back the sum at the rate of 10% interest per annum. Okay? So in that case, there is no period stated. Okay? So how do we know what the period is? Instead of going right away to declaring the contract void, we can still interpret it, no, according to the rules on interpretation of contracts, and that is greatest reciprocity of interests. We will now say that since there is interest at 10% per annum, then we can deduce that the period is meant for 1 year, and this will be beneficial for both parties. Why? Because now the debtor has a period of 1 year within which to pay the debt, and the creditor also has a period of 1 year within which to earn interest. So it's a win-win situation. So that now we have resolved the doubt in favor of the greatest reciprocity of interest. Okay? Next, what if the doubt concerns the principal object of the thing? You remember essential elements of contracts: consent, object, cause, no? If the object is absent or if it is doubtful, then the contract is void. Okay? Why? Because we cannot know the intention of the parties as to the object. And if the object is absent, then the contract is void. Final rule. Okay? In the absence of everything, no? Or even without that, no? In case it is applicable, the usage or the customs of the place will maybe applied to the ambiguity. What's one good example? Let's say repairs on a certain machine or a toy was made, no? And no price for the services was given. Then the price may be computed according to the common rate of the services around the area. Okay? So we look at the usage or the customs in the area. Okay? So that's it for form, reformation, and interpretation of contracts. Okay? Congratulations again to the bar passers, and I hope to see you guys for the next episode. Okay? Bye!